Good day, my name is Charlie Farner Jr. taking the final exam of CLJ 400. Rule 128, Section 1. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Rule 128, Section 2. Scope. The rules of evidence shall be the same in all courts and in all trials and hearing, except as otherwise provided by law or these rules. Rule 130, Section 1, Object as evidence. Object as evidence are those addresses to the sense of the court. When an object is relevant to the fact in the issue, it may be exhibit to examine or view by the court. Rule 130, Section 2, Documentary evidence. Document as evidence consists of writings, recording, photographs, and any material containing letters, words, sounds, numbers, figures, symbols, or other equivalent or other modes of written expression offered as a proof of their content. Photographs include still pictures, drawings, stored image, x-ray, films, motion pictures, or videos. Rule 130, Section 22, Testimony defined to personal knowledge. Witness can testify any to those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. Corroborative evidence is additional evidence of a different kind and character tending to prove the same point. It is a piece of evidence that may be derived from various sources but proves a common point. Meanwhile, cumulative evidence is additional evidence of the same kind and character tended to prove the same point. This is purely the accumulation of similar evidence that is derived from common sources. Prima facie evidence is evidence which is unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue is support. Otherwise said, if the opposing party does not offer an explanation and present contrary evidence, then the prima facie evidence will be enough basis for the court to rule in favor of the party that offers the prima facie evidence. Section 37, Dying Declaration. The declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his death is the subject of inquiry, as evidence of a cause of surrounding circumstances of such death. Section 44, part of the res gesti, statement made by the person while a startling occurrence is taking place or immediately prior or subsequent thereto, under the stress of excitement caused by the occurrence with respect to the circumstances thereof, may be given is in evidence as part of the res gesti. So also statement accompanying an equivocal act material to the issue and giving it a legal significance may be received as part of the res gesti. Rule 132, Section 5, Direct examination is the examination in chief of a witness by the party presenting him or her on the facts relevant to the issue. Rule 132, Section 6, Cross-examination, its purpose and extent. Upon the determination of the direct examination, the witness may be cross-examined by the adverse party on any relevant matter with sufficient fullness and freedom to test his or her accuracy and truthfulness and freedom from interest of bias or the reverse, and to elicit all important facts bearing upon the issue. Rule 132, Section 7, Redirect examination, its purpose and extent. After the cross-examination of the witness has been concluded, he or she may be re-examined by the party calling him or her to explain or supplement his or her answer given during the cross-examination. On redirect examination, question on matter not dealing with during the cross-examination may be allowed by the court in its discretion. A normal court proceed will take around 3 to 5 or even more years to be fully decided. By requiring the submission of witness affidavits of witness through the jar, the time for concluding a court proceeding will be shortened. The jar thus seeks to discongest the ever increasing consult is in the country, brought about the high number of cases filed each day and the lengthy procedure object. The jar also seeks to address any lost translation in interpreting the testimony of a witness, if the testimony was translated from a legal language into English. In quasi-offenses or acts defined and penalized under Article 365 of the Revised Penal Code and thus allowed by the law to compromise, their unusual examples are found in the Revised Penal Code, particularly Article 266 of the Revised Penal Code, or if a compromise was made before the filing of the criminal complaint. First, relevant evidence is a relationship to the fact in issue. If there is a relationship between the evidence and the fact in issue, then the evidence is material. Second, relevant evidence can lead us to the belief in the existence of non-existence of the fact in issue. If the evidence supports our belief that the aligned facts exist, then the evidence has probative value. Section 10, leading and misleading question. A question which suggests to the witness the answer which he examination party deserves is a leading question. It is not allowed except on cross-examination on primarily matters on an unwilling or hostile witness. A misleading question is one which assumes as true or a fact not yet testified to by the witness or contrary to that which he or she has previously stated. It is not allowed. Section 4, circumstantial evidence when sufficient. Circumstantial evidence is sufficient for conviction if there is more than one circumstances. The fact from which the interference are derived are proven. The combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. Rule 131, Section 1, burden of proof and burden of evidence. Burden of proof is the duty of a party to present evidence on the fact in issue necessary to establish her or her claim of defense by the amount of evidence required by law. Burden of proof evidence shift. Burden of evidence is the duty of party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. In civil cases, the party having the burden of proof must establish his or her case by the preponderance of evidence. In criminal cases, proof beyond reasonable doubt. In a criminal cases, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Revised Rule on Evidence, Rule 132, Section 6, substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence or that amount of relevant evidence which a reasonable mind might accept adequate to justify a conclusion. Classes of documents. For the purpose of their presentation and evidence, documents are either public or private. The written official acts or records of the sovereign authority, official bodies and tribunal and public officer, whether of the Philippines or in the foreign country. Document acknowledgement before a notary public except last will of testament. Documents that are considered public document under treaties and convention which are enforced between the Philippines and the country of such, and public records kept in the Philippines are private documents required by law to be entered therein. Proof of private document. Before any private document offered as authentic is received in evidence, its due execution and authenticity must be proved by any of the following means: by anyone who saw the document executed or written, by evidence of a genuineness of the signature of handwriting of the maker, or by other evidence showing its due execution and authenticity. A. When the original has been lost or destroyed or cannot be produced in court without bad faith on the part of the offeror. B. When the original is in the custody of under the control of the party against whom the evidence is offered and the latter fails to produce it after reasonable notice. C. When the original consists of numerous accounts or there are other documents which cannot be examined in the court without great loss of time and the facts so to be established from them is only the general result of the whole. And D. When the original is a public record in the custody of a public officer or is recorded in a public office. Qualification of witnesses. Section 20. Witnesses. The qualification except as provided in the next succeeding section. All person who can perceive and perceiving can make their known perception of other may be witnesses. Section 3. Extrajudicial confession not sufficient ground for conviction. An extrajudicial confession may by an accused shall not be sufficient ground for conviction unless corroborative by evidence of corpus delicti.